Porsha's attorney spoke now. As you guys can see on the thumbnail, it is Simon's attorney time to kind of introduce. So let's get into it, y'all.
Thank you, Your Honor. And I was timing Mr. Kessler. That was about a little over 30 minutes, but I'll try to keep it shorter than that. Again, so may it please the court, Judge. As I mentioned, so Ms. Williams is a well-known public figure. She is a TV personality, an actress, an author, an entrepreneur, an influencer, in essence, a celebrity, as most lay people would name her. So she gained her prominence back in 2012 as a public figure, and she's most known as a cast member on Bravo reality TV show, The Real Housewives of Atlanta, which the court would hear quite a bit about today. So the petitioner has become a notable figure in reality TV and in media. You'll learn that she's cultivated a very huge fan base and a large social media following, as I mentioned before, over 7.7 million followers on Instagram. Contrarily, Mr. Guobadia, you'll learn about him. He is a businessman, a self-made entrepreneur who worked in the energy and hospitality sectors. And primarily, you'll learn that majority of his income, about 97% of his income, was operating as the sole member of his business called Simcol Petroleum, S-I-M-C-O-L, Simcol Petroleum. And so Mr. Guobadia, contrary to Ms. Williams, is not a celebrity, not in the limelight, doesn't have that level of influence. But nonetheless, the parties began dating early 2021, in the spring of 2021. They became engaged, and later on that year, you'll learn that on or about September of 2021, Ms. Williams actually left her employment with Dish Nation, which is a TV network, and she also left her employment with the Real Housewives of Atlanta. You'll also learn that during this time, Mr. Guobadia was actually giving his girlfriend about $30,000 a month, just off the strength of being his girlfriend. And so also during that time, Mr. Guobadia took that into consideration that, you know, since she had left her employment with Dish Nation and also with the Real Housewives of Atlanta, two of her primary sources of income, that he agreed to pay his girlfriend $30,000. Well, not agreed, there's a formal agreement at that time, but he was voluntarily paying her that. So that way she would have some sort of financial means to take care of her day-to-day needs. The parties then began a discussion about entering into a prenuptial agreement towards the end of 2021, I believe, maybe around December of 2021, carrying into 2022. The parties did both hire counsel, they began negotiating, and you'll learn that during the negotiations, Mr. Guobadia relied upon the fact that Ms. Williams was no longer earning the average $1.6 million to $2 million that she was earning from Real Housewives of Atlanta as a cast member to the Real Housewives of Atlanta, and she was no longer earning her money from Dish Nation. And so one of the things that you'll learn about, and I'll just summarize kind of what the big issues are, or the big ticket items, I'll call it, in the prenuptial agreement. The terms of the prenuptial agreement indicate that Mr. Guobadia would pay $40,000 per month alimony, and that amount of time would be from the length of the marriage up to the time that she filed the divorce, not to exceed 36 months. So in this instance, the parties were married in November of 2022. She filed for the divorce February 22nd of 2024. So under the prenuptial agreement, as it reads, Mr. Guobadia would be responsible for paying $40,000 per month for, I believe that's 14 months. You'll learn that during this time of negotiations, that because Mr. Guobadia was providing or giving Ms. Williams $30,000 a month because she was no longer on Housewives, filming as a reality star on Real Housewives of Atlanta, that the negotiations surrounded her request of keeping a similar payment to her, but increasing it by $10,000, hence the $40,000 per month. The other term of the prenuptial agreement that is at issue here is possession of a marital residence. The terms, as it states, indicates that Ms. Williams would have 36 months from the divorce filing to refinance the debt or to fully remove Mr. Guobadia's name, or to sell the marital residence. The prenup goes on to indicate that if Ms. Williams cannot refinance, then she would have to list the home for sale after 36 months has passed. And then if she lists for sale or whether she refinances it, either way, the prenup indicates that the parties will have to split the equity 50-50. The other issue of the marital residence is that Mr. Guobadia, under the terms, would have to pay the mortgage, the taxes, the homeowner's insurance, utilities, the repairs, maintenance, landscaping, and HOA until such time that Ms. Williams either refinances or the home sells, but not to exceed 36 months. And also the prenup indicates that the losing party to contest and enforcement of the prenuptial agreement will be responsible for attorney's fees. So those are the main parameters of the prenuptial agreement that I believe are at stake here. You'll learn that the home that's at issue is actually Mr. Guobadia's premarital home. It's a $7 million premarital home that he purchased in November 8th of 2021. That was a year before the parties got married. And you'll learn that Mr. Guobadia actually sold 2 of his premarital homes, and he used the proceeds of $2.4 million as a down payment to purchase the marital residence. And for the record, the marital residence is located at...
Okay, guys, of course I had to cut it off because it's going to, say the address. So, can't get y'all folks' address, although it is public record. So we're just going to get into the next video, because since I had to cut it, now you'll get the next part of that.
Guobadia was the higher income earner during that time, and Ms. Williams was the lesser income earner. Your Honor will see from the evidence from the financials from the prenuptial agreement that Mr. Guobadia's net worth was estimated at $322 million, of which 97% of that stems from Simcoe Petroleum. Your Honor will learn that Simcoe Petroleum is a U.S.-based entity where Mr. Guobadia is the sole member of that business. At the time that the prenup was entered in November of 2022, contrarily, Ms. Williams' net worth at the time was $3.6 million. And during the time that the parties entered into the prenuptial agreement, it was always anticipated and foreseen that Mr. Guobadia would remain the higher income wage earner. In fact, they anticipated that his net worth would get greater. And specifically, I'll refer the court to page 2 of the prenuptial agreement. On page 2 of the prenuptial agreement, which I'll also include here on the screen for the court, page 2 indicates that the parties understand and agree that Mr. Guobadia's present net worth is greater than his present net worth as reflected by their respective financial disclosures. It is feasible and likely that the parties' respective net worths will continue to be disparate, and it is foreseeable that there may be a larger disparity in the parties' respective net worths in the future. The parties acknowledge that the provisions of this agreement will perpetuate the disparity in their respective net worths, that the parties foresee the perpetuation of such disparity, and that neither party considers the perpetuation of such disparity to be...
Okay, let me just jump in and say this. I did have to cover up half of that because it does show the address. So y'all can't see the prenuptial agreement because it shows their address. So just want to let y'all know.
Unconscionable. And the reason I highlight that is because the court will learn, based on the evidence and testimony, that it's just the opposite has occurred. Mr. Guobadia's income has reduced drastically. It was never foreseeable that his circumstances would change, where he would be removed from the United States, lose his business contracts, employees, and basically suffer a complete eradication of Simcoe Petroleum, which controlled 97% of his approximated net worth. Your Honor will also learn about the confidentiality clause that's at issue. The parties, and I'll just share my screen for the court to be able to follow along as I reference the confidentiality clause. Essentially, the court will learn that Mr. Guobadia lived his life privately as a businessman and entrepreneur prior to meeting or marrying Miss Williams. You'll learn that he has minor children from a previous relationship, and it was extremely important for him to have this confidentiality clause in the prenuptial agreement, which prohibits non-consensual recording of himself. It prohibits non-consensual recording of his private residence, his home life, his children, and it prohibits disclosure of his personal affairs, his business affairs, and his personal relationship and his marriage with Miss Williams. You will learn that Mr. Guobadia, it was very important for him to have some sort of provision in the prenuptial agreement that provided these privacy protections in the event that the parties divorced. Consequently, I know Your Honor mentioned contract law earlier to the interns. That is exactly what's at play here, because at the end of the day, prenuptial agreements are contracts, and the court has to determine whether or not it is an enforceable contract and whether it will be fair today to enforce the same. Consequently, Mr. Guobadia did negotiate and bargain for this confidentiality clause that's within the prenuptial agreement, and I will share my screen just so the court knows exactly which provisions I'm referring to. So it's paragraph 17 and page 24 of the prenuptial agreement, and it spans into page 25 of the 25 and 26 of the prenuptial agreement. In essence, I'll just summarize exactly what it contains in this prenup. In essence, it states that the parties shall not disclose, shall not publish, or provide information that discloses.
Your Honor, at this point, I'm going to object to this even being on the record.
Opening, but
Judge,
go
sorry.
Go ahead, Ms. Ferry.
Judge, and I was going to say, Judge, I'm not giving no word for word. I was just showing the verbiage on the screen so that way the court can make note when the evidence comes out. Mr. Kessler read the word for word discovery waiver, the word for word attorney's fees, and some other provisions. So I didn't want to get into that to save some time. I don't anticipate going for 30 minutes like Mr. Kessler did, Judge. I just wanted to point out some of the areas so that the court can follow along during the testimony. So it's just in summary, Judge, as it relates, and I'm just sharing it, but I'm not reading the word for word, Judge. As it relates to the confidentiality clause, and I think the reason why Mr. Kessler keeps objecting is he adamantly wants to prevent the court from hearing this. But when it comes to the confidentiality clause, in summary, it provides that neither party shall disclose or provide any information about the prenup, any information about their professional or business interests, any information about the financial aspects of their relationship. Neither party shall negatively disparage information about the other party, disparage information about their relationship, disparage information about the other party's family, disparage or disclose any information about their relationship with their family, or disparage any information about their professional or business interests. And then it goes on.
Your Honor, I'm going to renew my objection, and I'm going to ask for an extra 2 hours of hearing. If that's going to be relevant today and heard today, we'll have 2 hours of testimony about everything he said about her. And this is outside the bounds of what we're talking about.
Opening, Judge. This is opening, and I would ask the court, direct Mr. Kessler, to allow me, Judge, to finish my opening. I think it's very unfair that he is trying to cut me out so the court will not.
Let me just, Mr. Kessler, I know you're renewing your objection. I'm going to allow it an opening, and we can get into the question that seems to be appearing. I don't know. I assume Ms. Ferry is going to present this as an angle why the prenup was not. Well, I'll let her make her arguments, and I'll let you make your arguments. But for right now, I'm going to allow it in the opening. Go ahead, Ms. Ferry.
Okay, thank you, Your Honor. The other provision of the prenuptial agreement also indicates, and this is of importance as well, and this has been brought up time and time again in the filings that we presented to the court, that the parties are not to release, disclose, publish any photo, tape, film, recording of any aspect in or about the home, office, or other property owned, occupied, or used by the other party, or any of their family, friends, representatives, or children. That is the provision related to filming in the marital residence. The confidentiality clause also indicates on page 26 that neither party can give any interview, can write, appear, or assist or cooperate in the presentation or preparation of any book, article, interview, program, or other production or publication of any kind whatsoever concerning the other party. And those are the terms that Mr. Guobadia bargained for. Those are the terms that were very important to Mr. Guobadia. Those were the terms that he paid under the contract, or that he agreed to pay under the contract to secure that term. And essentially both parties ended up signing that contract on November 17th of 2022. They married about a week later on November 26th of 2022. And so after 453 days of being married, Ms. Williams, you will learn about for her divorce. You'll learn that Mr. Guobadia learned about the filing of the divorce after Ms. Williams submitted the paperwork to People magazine and disclosed it. He learned about it online. Nonetheless, Mr. Guobadia filed his answer and counterclaim. We attended a 30-day status conference, and that was on April 4th, 2024, before the Honorable Rabowski Houston. There was a temporary order entered, Judge, on May 31st, 2024. And the reason I mention that is because in that temporary order, the court may recall that the court at that time indicated that the parties shall participate in discovery and shall submit to mediation in preparation for an evidentiary hearing. There has been no mediation in this case, but nonetheless, that is why I subsequently, pursuant to that court order, then served the discovery request. I served the discovery request after the April 4th, 2024 status conference that said we shall immediately begin discovery, and that discovery had to be completed within 90 days. So, pursuant to this court's directive and order, I then served discovery on April 16th to True Entertainment. I served it on May 21st to Dino Bones, our previous employer. I served it on May 21st to City National Bank, and as well as Bank of America. Those accounts are with Ms. Williams' accounts. I also scheduled a deposition to take her deposition on June 25th of last year, 2024. And then I also served her on July 5th of 2024, request for production of documents, interrogatories, and request for admissions. I did that within that short time frame because we were only given 90 days to serve discovery pursuant to the temporary order. And then the discovery was to conclude on August 31st. And therefore, I did not serve any additional discovery after August 31st of 2024 because it was to conclude at that time. Nonetheless, fast forward May 20th of 2024, Ms. Williams files with this court a request for this court to give her an order to film in the marital residence against the prenuptial agreement. And so after that, there was a motion that I filed on June 25th because Ms. Williams was not complying with discovery. This was last year in 2024. We had a discovery status conference August 9th of 2024. We also then had a hearing on that issue of August 21st of 2024. After that hearing, Your Honor did issue an order on the motions hearing September 12th of 2024. And I understand the court's directive as we began regarding Pace v. Pace. I also just want to point out to the court that in the order it indicates, or it starts out with, quote, without making any adjudication as it relates to the enforceability of the prenuptial agreement as a whole, then the order goes on to explain the discovery issue. So I bring that up just to point out to the court that we're still here to discuss the enforceability, as the court knows, of the prenuptial agreement. Nonetheless, I did file a certificate of immediate review September 19th of 2024. The Court of Appeals did not accept my application, and that was, they denied my application on October 20th of 2024. After that, this court actually entered an order November 19th of 2024 that granted Ms. Williams' request to be able to film and record in the marital residence against the terms of the prenup. So in one breath, the evidence will show that Ms. Williams wants the court to enforce those provisions that are favorable to her, like occupying the marital residence, and Mr. Guobadia paying those expenses. But on the other hand, Ms. Williams does not want to enforce the provisions that are unfavorable to her, which is the confidentiality provisions. Nonetheless, I filed a motion to vacate that order, and that motion is still pending. I filed a motion to vacate that order on filming in the marital residence on December 19th of 2024 on those grounds, based on Ms. Williams seeking to enforce if she was seeking to enforce a prenuptial agreement, it essentially prohibited her from filming in the marital residence without Mr. Guobadia's express consent. I would request that, if the court certainly enforces the prenuptial agreement, I think the court is incumbent and required to vacate that order that gives her the right to film in the marital residence, because by enforcing a prenuptial agreement, essentially Ms. Williams would have to abide by those confidentiality terms. Fast forward, this court did schedule this matter for a final hearing. That rule nisi was issued on December 23rd of 2024. We were initially scheduled to be heard on February 26th of 2025. Your Honor may recall, because we were here twice before today, that Mr. Guobadia unfortunately was detained by the government, by ICE, at the airport a few days prior to the hearing on, I believe it was February 19th of 2025. So the case continued. And as I mentioned earlier, Mr. Guobadia had been detained for several months up until, I believe he traveled last Friday, June 6th, and then was transported to Nigeria, where he is currently and has been since Saturday, June 7th of 2025. So during that period of time, there's argument from Mr. Kessler about Mr. Guobadia not paying the fees and expenses to the marital residence. The evidence will show certainly that Mr. Guobadia was paying everything and operating his business, Simcoe Petroleum, up until he was detained February 19th of 2025. That's evident just by the mere record not showing that there's been any contempt filed against him. Nonetheless, after that, he has not had any access to any of his devices, as I've mentioned to this court before. He didn't have access to any laptops. He didn't have access to any personal information. He had limited access to me and information as his counsel. He was not able to attend the court remotely while he was detained in a detention center, as the court is aware as well. And so this matter had to be reset twice. And so here we are. Essentially, Mr. Guobadia is removed from the United States. You will learn and hear from Mr. Guobadia that he was removed from the United States and charged by ICE for one thing and one thing only, and that was using a different variation of his name. That was the charge, and they removed him. So there is a material change in circumstances that was not foreseen by either party. It has affected his ability to operate and earn income from Simcoe Petroleum, which the evidence will show is 97% of his business. And so what we are asking the court to do is, we are asking the court to deny the motion to enforce the prenuptial agreement. The burden of proof under Scherer v. Scherer, the Supreme Court decision that leads the line of cases surrounding this issue, the burden of proof rests on Ms. Williams. She has the burden to prove to the court three things. She has to prove to the court that the facts and circumstances have not changed so much that it would make the agreement unfair. She has to prove that her financial circumstances, for example, has not changed so much so that it would make the agreement unfair and unreasonable. She also has to prove that Mr. Guobadia's financial circumstances have not changed so much so that it would make the current terms of the agreement unfair and unreasonable. She also has to prove that the agreement is not unconscionable, or that it wasn't unconscionable at the time that the parties entered into the agreement. She has to prove that there were no misrepresentations about her income, her intent to leave the Real Housewives of Atlanta, or any non-disclosure of material facts. She has to prove that there was no fraud as it relates to that. And she also has to meet the bare foundations of contract principles. She has to show that she has not violated any provisions of this prenuptial agreement. And so we contend that the evidence is going to show just the opposite, that the court is going to be compelled to consider setting aside the prenuptial agreement. And if the court sets aside the prenuptial agreement, the question of what happens next is exactly what would happen in any other divorce proceeding. This matter would have to proceed on the normal divorce track, which would be the parties engaging in discovery to determine what the equitable equitable division of marital property would be versus the separate property, and have a hearing on that. But as I mentioned, if the court enforces the prenuptial agreement, in essence, the court must vacate and set aside that order that allows filming in the residence. There was a request from Mr. Kessler about issuing a judicial deed and allowing her to transfer the deed to Ms. Williams' name, and also awarding her the house. Again, Judge, back to what I mentioned a few seconds ago, Ms. Williams seeks to have relief that benefits her and make argument towards that, but if there's a relief that does not benefit her, then she does not want the court to follow it. What I mean by that is this court is well aware that if the court enforces the prenuptial agreement, the court can't rewrite the contract. And that's exactly what Ms. Williams is asking the court to do, is rewrite the contract. The contract does not say that the deed will get transferred to the wife's name. The contract says that she will make efforts to refinance, that Mr. Guobadia would cooperate, and they will execute any documents necessary. Or if she cannot refinance within 36 months of February 2024, then it states that she would sell it. And the contract indicates the parties have a very detailed step-by-step process by which they have to solicit, or not solicit, but elicit or list the sale, or list the property, for sale. They have to contact appraisers. They have to contact real estate agents. It's a very detailed process within this 30-plus page prenuptial agreement. And so the court cannot just issue an order awarding the house to Ms. Williams. Again, that rewrites the contract. And so many of the relief that Ms. Williams is asking the court to do, if the court enforces the prenup, ends there. So I'll leave that with, if the court decides to enforce the prenup, that is all this court would do, is enter an order that says it grants the enforcement of the prenup. To then enter an order that delineates other steps and things that may occur, that's in direct contradiction of contract principles, and that would be beyond the purview of the court when it comes to enforcing a private agreement. Nonetheless, we are asking that the court not enforce the contractual agreement. I think the evidence will show that it would not be fair to these parties. It would not allow Mr. Guobadia or even Ms. Williams the benefit of their bargain. And so that would be our argument for today, Judge.
Okay.
And
I didn't realize I was on mute. So after that, we kind of went on break. So this is a good segue. So what I want to explain is what she said is exact. And I'm not a lawyer, but the way she explained it is pretty much the way that it is. So we all know what the ruling was, because I came on live yesterday and I told y'all they ruled in favor of the prenup. Well, it's either the prenup, you're going to enforce the prenup, or you are not. There's no in between. So what Simon's and here's the deal, y'all. I feel like Simon had a really good attorney, but what y'all need to understand is sometimes judges already have their mind made up. And I feel like this judge already had his mind made up. I feel like he was tired. I feel like he was exhausted. And I feel like he only did this hearing because he wanted to appear to be fair. And I'm going to tell you why. Because you don't have to be a lawyer to understand this. Enforcing the prenup is just one thing. But once you enforce it, the court is done with it. Enforcing the prenup means enforcing everything that is within the prenup, which is everything that Simon agreed to do. He agreed to pay her $40,000 a month for the next for 14 months, right? Because they were married for 15. So he pays her 40,000 for the next 14 months, and I believe that's about 560,000. He would also pay all of the expenses in the house. Now she has a total of 36 months to either refinance the house into her name, because if she don't, then it needs to be sold. But at that point, Simon does not pay for her anymore in the house. That is what the prenup states. Remember, Simon wants to not enforce the prenup because Simon said his income is reduced. He's saying he was removed from the United States. His large fortune has dwindled. It's pretty much what Simon is saying. The judge is like, oh, well, too bad, because we are enforcing the prenup. So what Simon's attorney is saying, that's like a one thing. You enforce the prenup. But what the judge did is he said he was enforcing the prenup, but then he also made rulings against the prenup. And that is what the attorney was saying. You can't, if you're going to enforce the prenup, then how are you going outside of the prenup? Because keep in mind, guys, the prenup is the paper that they both sign. So if the judge is saying I'm going to enforce it, then you enforce it. But enforcing it means that Porsha can't film in the house, because that's what it says in the prenup, if y'all understand what she just said. So what Simon's attorney is saying, how are you enforcing the prenup, but now you're making rulings outside the prenup? Then you are enforcing some portions of the prenup. And that is what Simon's attorney said. Okay, the court is not going to rewrite the agreement. But then if the court is not going to rewrite the agreement, then is the court really enforcing the prenup, or what is really going on? My opinion is, I feel like Simon got deported, and I feel like the judge really didn't give a damn. That's just what I feel, because the judge knows I'm enforcing the prenup, but then you enforce it all. So literally what the judge did, he said that we're going to have a hearing on the prenup because he already ruled to enforce the prenup. But Simon said, I object. They wanted to have this, trial by judge where they present their evidence. The judge kept his original ruling and said, I am enforcing the prenup, which told me this judge does not like to go back on stuff that he previously said. And he said that in the beginning. So it's like he just went through this for the heck of it. But if you are enforcing the prenup, then you are enforcing everything in it. That's what I'm trying to get y'all to understand. He didn't do that. He enforced most of it, but then he changed it. And it's like, you said that, you were just, so it's just like, and that's why I was saying in my first video, I said, is the judge biased? Because if you are enforcing the prenup, then it's enforcing everything that's in it. The prenup is one document. It's not a combination of you pick out what you want to do and then, you pick out the stuff you want to do and we'll just go with that. No, you have to go with the full document and all of the contents within it. And that's where it seemed crazy, because the judge was like, okay, I'm enforcing the prenup, but you're not, because the prenup states that Porsha can't film in the house, but the judge allowed her to film in the house months ago. And then when they came, as Simon's attorney said, she submitted an objection in December. It is June, and the judge never even ruled on it, never said anything. So now we are in court yesterday, and the judge was like, well, I'm not changing it. But how then are you enforcing the prenup? So that's just something, for y'all to, think about. I thought it was very different. I thought that, enforcing the prenup, it is correct. Enforcing the prenup is enforcing every single part of it. But why did the judge change that part of it and then said he was enforcing the prenup, and that's why I said, was the judge a little bit biased? I feel like Simon's being removed from the United States, probably made the judge feel like, well, hell, you're not here anyway. I'm going to just do whatever, because In all honesty, if you are enforcing the prenup, you are enforcing the entire document and not portions of it.